Okay. So we have the purchase and sale printed out. I wanted to go over this in depth, just like we did the buyer agreement and listing agreement. I know, Tim, you weren't here for that at the moment. And it's really a matter of, as professionals, we need to know the ins and outs of the contract that we are presenting to our clients, to be able to answer questions for them, make them feel comfortable and confident, write the offer in such a way that we're protecting them, and also to know all the loopholes, all of the exit strategies, etc. My goal is to be able to go over the purchase and sale agreement, and then also as a means to get you more and more comfortable with Command and DocuSign and thinking outside the box when it comes to writing offers. We'll also, I'll send out you different scenarios and you all can write offers. It could be like the same person in Command, but you write just different offers over to me to present. And that way, when crunch time happens, you've got a client, you've got X amount of time, when the real life happens, you've already proficient. You're comfortable and confident with DocuSign. You're comfortable and confident with the purchase and sale agreement, along with the exhibits and when to use it, the strategy behind it. I want you all to be like the absolute best professionals, where you get compliments from listing agents saying, that's the best offer I've seen in 2 years. Whether it was their price or not, it was constructed in such a way that you instantly reek of professionalism the moment that your offer comes through. So just like just like our buyer agreement and our listing agreement, so we have section A along with section B and C. Now, section A is all of our key terms on the front page. Thankfully, Georgia has updated, and then section B starts on page 2, and that references. So you have A1 that's talking about the legal description. So then you have B1, and it's going to mirror. So as you're talking to your client, you're kind of explaining to them, because they're going to look at this and you're going to talk about earnest money or perhaps closing costs, and there's nothing here other than seller's contribution at closing, and there's a blank space. Well, if we reference B3, it goes into more detail. So, okay, again, so on page 1, kind of just going through purchase and sale, undersigned buyers agree to buy and the undersigned sellers agree to sell as described below, including all fixtures, improvements in landscaping, therein on the terms and conditions set forth. So we have the address, and this is where, and I'm going to talk a little bit about my nuances, etc., that I've picked up over the years. I spell out the word circle. I spell out the word trail. Northwest, I don't spell out necessarily. However, you want the full address on there. Blue Ridge, LJ, and Cherry Log, especially when it gets kind of that Cherry Log situation or whichever, you're ultimately, and you've got lenders involved, there's a site on the USPS website. Lenders and attorneys, they're all going to default to whatever the United States Postal Service has. So if you're like, I think this might be a Blue Ridge address or a Cherry Log address, etc., on those nuances, just double checking with them. And sometimes you can just leave it to the lender. They'll end up catching it. City, county, zip code, MLS number. If it is not listed on the multiple listing site, you don't leave a blank space. We just type in the word NA. Tax ID, parcel number. You can typically get that on a listing agreement. You can use QPublic to find it. I would double check it. Sometimes you can get the seller's name if they filled out a seller's disclosure. You want to make sure that your tax ID is populating the right thing. Sometimes you'll find it where it goes to nothing, especially if it's a land lot and they have tax ID number as 0. Then you got to start going to QPublic and start hunting. Legal description. It is not a binding contract if it doesn't have one of these 4 options here. If you're relying on the listing agent to do their job and fill out the numbers and fill out the lot information or fill out the deed book and page and such, double, triple check. Most often I've found with section 4, we don't have all of the information to fill out every single box. The best option to use would be if you can go to gsccca.org or .com, and get the warranty deed. And again, you want the most recent up to date, not to owners prior, to be able to attach as an exhibit. After that, if you're not able to access that, if timing isn't on your side and you can't use an attorney to like, hey, can you pull this for me? I can't hunt it down. Then use section 3 to be able to find deed book and page. But that's really where your GSCCA is. If you have the deed book and page, or if you can hunt it down by their name, you can most often find the warranty deed. But again, sometimes you're going to have to get an attorney involved because the listing agent might not have either one there and you're just scrambling. But really, you can't even put in a stipulation that says, oh, we'll add that at a later time. It is not a binding file. Any questions on that? Okay. Purchase price, it used to be where you had to write it out as if you're writing a check. Now it's just numbers. I try to leave very little to the imagination. I type in, if it's 250, 250, comma, 000 dot 00 for the decimals. I had an attorney, former, she was an alumni with me at my college, and she's like, absolutely write it all out. When it comes to closing costs, or really any dollar amount that I just need to write the word in zero, because back in the faxing days, we would, it would get muddy. I'd literally write the word ZERO instead of just a zero, because it's so easy to add in numbers all around that zero. You would think that you don't imagine that somebody would be malicious. However, just leaves little error to type out the word zero. Closing date, I am the queen of writing closing dates on holidays. Columbus Day, I got it. Arbor Day, I got it. Like any holiday you can think of, I have tried to put a closing on it. So we only close Monday through Friday. You will still get the questions of, do we close Saturday and Sunday? Absolutely not. You know, I could be there. The attorneys are not going to be open and your wire is not going to get transferred. So no, we still Monday through Friday, not on holidays. Wonky, it gets wonky right around Thanksgiving. Most every place is closed the day after Thanksgiving. They try to get out of Dodge the Wednesday before. I've come to find more and more and more people are wishy-washy about the last week of December. I know that there's someone in Blairsville or somebody that closes. They're like just done. New Year's Eve, most everyone nowadays is closed. So just really reference your calendar and your holidays before you put the closing date on there. And you want to give them, I was talking to a paralegal yesterday at football, and they're starting to get to where the title is getting to take 5 days to get returned, even on rush orders. So cash deals, you sometimes could close inside of a 2-week, time frame. I would really try to give the attorneys as much time as possible. You want them to review and double, triple check everything. They almost sold a lot to a seller who didn't own it. They almost helped a seller sell a lot who didn't technically own it. And it was because, well, first of all, he kept demanding his money, but had it been rush, and like a 2-week turnaround, et cetera. But by giving them just an extra minute to breathe and to think through, and like something doesn't sound right, and then more time to discover, and they were able to discover it absolutely was not him, and did not send him the money. But I would really try not to close faster than 2 weeks or even around 2 weeks, but it's going to be talk to the attorney first before you put them in that kind of position. Same thing when it comes to financing. Talk to the lender before you start giving them due diligence days.
How do you go about like when you're picking closing attorney, because a lot of people are buying here and they don't live here, so they don't really know. Do you just say, hey, these are a couple of the closing attorneys that I recommend, or
I pick on it. First of all, in every county, I have a preferred closing attorney that I've worked with several times over the years. You want to make sure that they communicate well with you. You want to make sure their staff communicates well with you, and everybody else plays nice with everybody in the sandbox. You also want a proactive attorney. I've written people off that should have found out X, Y, and Z, or should have kept me in the loop on X, Y, and Z, or
Do you leave it to your clients to choose?
No,
or
I
you
really
just kind
don't.
of like, hey,
A lot of people defer to me,
you
absolutely.
just ask them, hey, do you mind if I just go with a closing attorney that I've used?
Right. And most
Right.
often you're doing a walkthrough. So picking someone, so fortunately Thomas and Brown will come here, but that's something I keep in mind of like Hiwassee closing. I'm not going to force them to come all the way down here to close. I will try to find someone local, but again, I want to make sure that they're going to, that's the last experience your client has with you. And you don't want them to be pulling their hair out from talking to whomever at the front desk at that office. So I'm very mindful of who I close with. But then I also explain to them, um, and we do try to find someone depending on where the seller's located as well. You try to find that neutral spot if you can, while also being a good experience. Purchase price, closing date. Don't forget those boxes on the bottom. Are this buyers receiving? I always 99% of the time choose upon closing. Now, prior to writing the offer, I'll have the discussion with the seller to get an understanding of where is it that the seller's going? Do they have a house already selected? Like, talk to me about possession. If the seller keeps the house longer than 30 days, it automatically turns into a tenant landlord situation. And it's that much more difficult to, remove them from the house. You also are, they can, they can. Um,
Now, whenever you do like an extension, like say it's 10 days after closing,
Mhm.
it has to be in the condition it was at closing,
At the time of binding.
at the time of binding. Okay.
Mhm. Or at the time of writing at the time of writing the offer, I think. We'll read
Okay.
that on the section B or section C.
Yeah.
That's why we do
'Cause, like,
walkthroughs.
here in the beginning where it says, they agree to sell real property described below, including all fixtures, improvements, and landscaping.
Mhm.
Like, if you don't want the cherry tree in your front yard to be, like, it needs to be gone before you even like list, right? Because if it's, unless it's stated on like a list of things that's not
Right.
transferring.
Yeah,
you
yeah.
don't even want it.
You need to be
advertised,
clear.
like,
Mm-hmm.
Okay.
Yep, needs to be either removed and or, right, there is a section on the seller's disclosure on the bottom of the second to last page where it states these items do not remain, or these items aren't working. Mhm. Going back to possession, that starts to also become like an insurance situation. So if the seller's retaining, possession, you want to make sure that they have renter's insurance, because the buyer, the owner, technically the owner at that point, will have to have full-blown insurance, but you want to make sure that they have renter's insurance, depending on how long they stay. Now, if it's a day or two, I mean, sure, should they have it? Absolutely, to cover bases. Will they get it? Most likely not, unless it's stated. But that's where you start to run into, well, maybe we can hold money aside to ensure that they're going to do the right thing. For instance, I had a situation where the seller had two massive, excessively massive aquariums, and there's no moving that to inspect it to see if the floor is damaged. It's the one-time move, and those hardwood floors, and there was just something about it that my client was very concerned about, the floor being damaged or just anything being nicked and damaged as they're leaving. And people would like to hold, they want to do an escrow holdback, so the seller is to receive like $25,000 in proceeds. They would like to maybe hold back 5,000 of that. Some attorneys will hold it, and they're waiting, it has to be spelled out so very clearly. Um, the buyer has to do the walkthrough, the buyer has to give the go-ahead, that, hey, everything is exactly the way it needs to. You can release the funds back to the seller, or, okay, they just pulled that aquarium out, the floors are completely water damaged. I now have to fix this and replace this. I don't agree with the condition. I want that 5,000. It gets to be very muddy, no matter how much you spell it out. That's my experience. So it's case by case. Some attorneys won't even hold earnest money. They'll give the check to the buyer to hold on. And again, that not everybody has to be in agreement with whatever's decided. So you try to avoid that at all costs. But again, there's lots of outside the box thinking. The holder of the earnest money. So Most often, so as the buyer's agent, as you're writing this, my go-to is to have the closing attorney hold it, especially if it's cash, a cash buyer. They're closing faster anyway. Most often, if it's held by, let's just say Keller Williams Realty Partners, we have to physically get it down there. It has to cash. It has to sit in that bank account for X amount of days before then they can cut that check back to the attorney for closing. Sometimes that's not enough time if you're doing a quick closing. And I like when it just makes it easier all the way around. Because when you go to closing, you have to bring that earnest money. So the Keller Williams is cutting that check to Thomas and Brown, let's say. Now you have to go and get it. It's just so much easier to, yes, it's 2 more documents, but it's just easier to have the earnest money held by the attorney. And with that said, if there's a dispute on earnest money, it's the closing attorney that has to review it, has to do the 10-day letter, has to be that mediator, that negotiator between the two parties on who gets the earnest money. So that's something else to think about. So the holder of the earnest money and the closing a law firm. I just saw Cheryl King post on Facebook this morning, have it be the same office, the same closing attorney office. Don't have different attorneys close and hold earnest money. I don't know why you would, but clearly somebody's done it if she's mentioned it. Earnest money, there's 3 options. A means you have the money in your hand, or the holder has the earnest money in their hand as of the day that you're writing the offer. That typically 10 times out of 10 doesn't really happen. Unless you terminate it on something else, they're already holding it anyway. B, I write in the exact amount, again, 5,000.00 within typically 5 days. Even if it's on a Friday, you lose 2 days, but you can typically get it wired. They used to have, they do on the land and the lot contract, but they used to have like how it was being sent, and I now see that that's been wiped out. So it doesn't matter if it's a check or a wire. Yeah. Section 8. So properties being sold subject due to a due diligence period of blank days. And this obviously, depending on the market and what we're seeing, could vary. During the COVID days, it was 0. Years before that, it was 14. Like, it could be anything in between. You want it to be reasonable. And this is all about tactic and negotiation when you're talking with your buyer. Are there other offers on the table? Well, then you got a minute. If there are offers on the table, this is one of many areas in which you've got to be aggressive. You want to look as attractive. This is what I say. You want to look as attractive as possible to the seller while we're protecting your best interests. We're protecting your right to get the house inspected. If I do 3 or if I do 2, I have already been on the phone with my go-to inspector and I'm like, pencil me in. What do you have? Can you do this? Because same thing with the lender. I'm not going to put in an arbitrary date or a time frame if I don't know if somebody can perform in that time frame. So it's being sold subject to a due diligence period of X days from the binding agreement. We all know that if you go under contract today on a Tuesday, day 1 starts tomorrow, the following day.
Is 7 days generally like a comfortable due period?
It just depends. You got to run a temperature check with the listing agent. How hot and heavy is the house? Do I have like 10 days the time that you walked in that inspection? I had 10 days because they were coming back into town. If I know that I have an out of state client, and I know they physically want to be here during the inspection, I'm talking flights, I'm talking when are you going to be here? And I'm, taking a look at it like that. But I have written it as short as like 1 or 2 days. And I also use inspectors that get us the report back same day. Okay.
Most inspectors can get you in about 2 days.
Don't count on it when rates come down.
Yeah.
That's why you really have to be on a consistent communication with your appraiser, inspector. Yep. So the section B was not really used until we saw COVID. It was in there, it just wasn't really used. So it's option payment for due diligence period. I know North Carolina has a little bit of this. So here in Georgia, in consideration of seller granting buyer the option to terminate this agreement, buyer can either, they've paid $10 in non-refundable option money, the receipt and bank, $10, plus that's also part of the legal jargon. Because we're getting into shall pay directly to seller additional option money of. So they used to have it at the very top of the contract, all things in consideration, et cetera, $10 to make it that legal binding. So it says to shall pay directly to seller. So again, not a check to the attorney, an additional option money of, let's just say, $1,000. And this, it actually mentions if it's going to be check, ACH, or wire of immediately available funds, either as of the offer date or within X days of the binding. Here's where we go. Any additional option money paid by buyer to seller shall or shall not be applied toward the purchase price of closing and shall not be refundable to buyer unless the closing fails due to the default of the seller. Basically, this is non-refundable money.
Yeah.
I am willing to put down, because the earnest money, again, that's section, thank you, section 7. So B7 will tell you, and the section B8 about due diligence, we'll read in the next section how the buyer can terminate and request earnest money. This is flat out saying this is option money. It's non-refundable. This is your way of looking at more attractive. The only option you have at the bottom is shall it apply to the purchase price or not? So purchase price is 100. I pay, because earnest money is applied. I pay $8,000 towards earnest money, so that's going to be reduced to $92,000. Well, I also want to pay $2,000 in addition to, and that just could be, hey, that's vacation money, seller, or it could be applied to the price, and now I only owe 90. But this is so you have the additional amount of money, and this is again back in the multiple offer situation. This is another tactic. This is basically buying off the seller. Exactly. It's money that you're comfortable with. Like you still have the right to terminate. You do not have the right to request this money back.
It's like slipping somebody a 50 for.
Pretty
It
much.
gets the table up close like a window.
Yeah. Yeah. How badly do you want this money? Yes. Lead-based paint obviously is built in 1978 or it's older. We are adding on the lead-based paint exhibit.
And it's not if it's still, it's like if anything inside.
If
the home.
yes, if any fixture inside the
Even if all
home,
of-
yep. Yes. I'm going to repeat that just in case it didn't capture on this. So any fixtures in the house, such as sliding barn doors or yes, mantles, decorative mantles, anything that was in existence prior to 1978 could potentially have that lead-based paint coating on it. You have to disclose it. And as a buyer's agent, you don't know what you don't know. So really the listing agent should have that as an optional disclosure to download and pre-filled out. So there have been times where I knew that the house was older than 1978. There was not a lead-based paint exhibit. I didn't say, I mean, I marked it in the exhibit section and I put a blank one on there. And I did not let my seller sign it or buyer sign anything. It was completely blank. Hey, I'm lobbing this over to you. I need your person to sign it and date it. My person sign it and date it before we can even slap a binding date on it, on the whole contract. So again, you want to get ahead of that. Section 10, brokerage relationships in this transaction. Buyer's brokerage, Remax Town and Country, seller's broker, Keller Williams Realty Partners - Blairsville, I think is what we're putting, or Keller Williams Elevate soon. If we're the buyer's broker, oh, I just said that as if we're the listing agent. If we are representing the buyer as a client, if we're representing them as a customer, we need to mark that. Most often, we will not have a dual agent representing both sides. I hardly ever see that nowadays. It does happen. If Taylor with Keller Williams Realty Partners has a listing and I'm writing an offer, I am selecting for anyone in our brokerage, not Keller Williams in general, our brokerage right now, because we're still tied to Woodstock, even in Woodstock, we have to select number 4 and we have to spell out our names. So I'm representing the buyer, so I'm Christina Young, and he's representing the seller. Yep, so you're selecting number 4 and you're writing your name. Material relationships. It'll go over this in section B, but that's typically direct connection or
Like if I were to list my father's house.
absolutely. If you were to live to your father-in-law's or if they're your family of any
Right.
kind, right? You don't have to put, oh, these are my best friends from whichever, because if you're not monetarily or they're not monetarily, um, if they're not monetarily benefiting in that, yes. But again, 10C, we'll read about that a little bit more. Time limit offer. It depends on the market, and I say that because there was a time there where I would write time limit offers and sellers were literally sitting there and they were letting it expire because they were waiting to see what else came up. Sometimes it can force their hand, like, I need you to respond within the next 24 hours. Some buyers don't want it to sit out there because if it does not have a time limit and it sits on the seller's table, there's no expiring it. You have to write a separate piece of paper, and it does exist. It's a GAR form, and it's basically like, hey, I'm going to remove it from your table. It's no longer an option. Um, there is that document. There were times where during the heyday of COVID, you weren't putting an expiration, or you're asking, hey, what day are you reviewing these contracts? Monday at 6 p.m. Okay, great. I'm going to expire it like Tuesday at 6 p.m. or something like that. Because you just didn't want it out there. Crazy scenario would be like 3 weeks later, the seller agrees to it. They're like, oh, I didn't get any offers or didn't get as many showings as I thought. This is still alive. I can sign off on it. So putting an expiration date, giving them no less than 24 hours, finding out, from the seller, what's your seller's situation? Are they on a cruise? Are they like hiking, backpacking in the middle of wherever? How, where are you, seller? Are you at a wedding or life happens? So just kind of getting an understanding from them as well. And then of course the buyer initials at the bottom. Also know that a couple of years ago, they started adding in our names at the bottom of these forms. So this form is copyrighted and may only be used in real estate transactions in which Christina Young, or you enter your name, is involved as a real estate licensee. So you can't print blank forms of these and just hand them out to whomever. Okay, so section B is going to go into further information on A. I'm realizing might be a 2-parter class. Okay. So seller warrants that at the time of closing, seller will convey good and marketable title to said property by limited warranty deed, subject only to zoning, general utility, sewer, drainage easements as of record of the binding agreement date, ensuring that driveways and walkways, et cetera, don't encroach, ensuring that they have declarations of condominium and declarations of covenants, conditions, and restrictions, CC&Rs on record, and leases of other encumbrances. Buyer agrees to assume seller's responsibility in any leases specified in this agreement. So if a house that's under a long-term lease per se is leased out and rented, this is another pinpoint here where buyer agrees to assume it. So you're buying it in September, but the lease doesn't end until November. You're buying a house with a lease until November. It does not automatically end that lease unless that seller has been in conversation with them. They are aware it's a month to month, whichever. But that's something to find out, especially if they're wanting to use it themselves. Did you have a question?
No, I read it again and it says as of closing. And so I was just like, so if you were to get under contract and then you find out that there is an encroachment or that you're encroaching on something, the seller doesn't technically fault until it closes. correct?
Well, they have to provide good and marketable title.
Yeah.
So if you're
But they
finding,
don't know that it's encroachment until you do a survey,
Mhm.
and then now their property is on someone else's
right,
land.
you have to give them time to be able to clear.
You have to be able to-
This is where they give notice of, and this is typically where the attorneys will give you notice. That's why it's so important to have good attorneys to notify the agents of, this is what we just encountered. This needs to be corrected. So you're finding out first, not last. Also, that's another thing is that when the title comes in, buyer may examine the title and or obtain a survey of the property and furnish seller with a written statement of title objections at or prior to the closing. If seller fails or is unable to satisfy valid title objections at or prior to closing, or any other lateral extensions which would prevent the seller from conveying good and marketable title, the buyer, among other remedies, may terminate the agreement without penalty upon written notice to seller. Good and marketable title is used herein shall mean title, because good and marketable title is also capitalized. Is that why they're given the definition? Is it capitalized in the other section? No, it's not. Okay. Good and marketable title shall mean title in which a title insurance company will insure it at regular rates.
But that doesn't mean they'll get their earnest money back, correct? Because of,
Yes, the seller is not able to provide good and marketable title and they've asked them to clear it up. They've given them written notice. And if they're not able to provide it, then yes, they have every right to be able to terminate. Yes. Again, that goes back to the holder of the earnest money and how they read it. Because you can't sit there and say absolutely without a shadow of a doubt. So that's right. But I also just in good practice and say that's where we request your earnest money back. I never say, we're going to write up this termination and you're going to get your earnest money. This is where we request it to come back to you. That will save you.
Should come back to the outcome for sure.
Right. I mean, if it's blatantly obvious you're in your due diligence period, you're in your due diligence period. Buyer hereby directs any mortgage lender involved in this transaction to quote the cost of the title insurance based on the presumption that buyer will be obtaining an enhanced title policy insurance. So when they get a loan, they have to get a title insurance. There's like two different policies, one that protects the owner and one that protects the lender. Lender all day long, you have to get it. It is optional as to whether or not you want to get title insurance. I mean, even regardless of the encroachments, etc. Because that sometimes can come out later, like the neighbor could come out and try to battle you over property lines, or Billy Bob's cousin's auntie sister, just like the whole lineage could come back and they say, I have claim to this property, and it didn't come back through the title chain. So it is when you're talking with your clients, and this is also something that we're going to have as our template when we go under contract and we're sending out our clients templates for CYA purposes. This is one of them, talking about title insurance. The importance of, you have the right to get it or not get it. Here's the importance of it. And I did my job because I'm educating you.
So, aren't there certain like loans that require you to have title insurance?
Requires them to have title insurance to cover the lender. Because, yeah, so two different. Purchase price to be paid by buyer. The purchase price is obviously in US dollars, delivered by such method of delivery acceptable to the closing attorney, including but not limited to wire transfer of immediately available funds. It has to be wired. If it's over $5,000, the closing attorney, and I think it's a Georgia law of some kind, it has to be wired. There is no coming in with the mattress and ripping it open with cash. Okay, closing costs. This goes into a little bit more. So again, how it's read on section A is closing costs, seller's contribution at closing, seller's contribution towards the buyer's closing costs. So that's A. At closing, seller shall make the reference seller's monetary contribution, which buyer may use to pay any cost or expense of buyer related to this transaction, including without limitation, any compensation obligations of buyer, compensation, AKA commission. Buyer acknowledges that buyer's mortgage lender may not allow the monetary contribution to be used for some costs or expenses. In such event, any unused portion shall remain back to the seller. So seller agrees to $5,000. It's really the lender that is plug and playing where they can use that money. And so we have a settlement statement at the time of closing. Some lenders, you can see a flat $5,000 credit from seller to buyer. Other lenders will break it up and you'll see like 350 here, and they'll literally just break it up and you'll see it all over the settlement statement, and it totals up to 5,000. Neither one's right or wrong. It's just how that lender operates. It can look a little confusing though when you run across someone that divides it out. But at the end of the day, it's the lender that does or does not allow them to use it towards certain items. And you want that lender that's going to use every penny, because that's called leaving it on the table and it going back to the seller, and you don't want that.
And they also can only get a certain percentage of the sale price too, depending on what loan.
Right. Right. Yep. FHA, conventional 90% or conventional 80% is different on, so that's another thing. So that, especially when you're starting to, negotiate inspection items and you want to increase the closing costs, but you've already at max, and that starts to become creative. You have to start really thinking outside the box of how else can I get my client money when they're maxed out on what they can get closing cost wise. Absolutely. Additional items paid by sellers. Sellers shall also pay the fees and costs of the closing attorney to prepare and record title documents for seller not attending the closing in person. Sometimes it's $100, mail away fee, or to handle and deliver seller's profits, payoffs, and proceeds. So regardless, so seller could pay nothing of the buyer, but they are paying B. They are paying to record the title information, to pay off their loan, and if they're not attending closing in person. Items definitely paid by buyer. Georgia transfer fee, the cost of title search and tax records, and to prepare the warranty deed, and any other costs and fees related to the transaction, such as lender fees. It spells out the proration. So this is where one of our agents had a seller that's like, absolutely, I do not want to have somebody come after me for assessments that are not locked in now. They're talking about in the future. I wanted to say that they can't come back. This is where we pointed it out to him. Ad valorem property taxes, community association fees, waste, government, utility bills, et cetera, that cannot be terminated as of the date of closing shall be prorated. So notwithstanding any provisions. So in the event of ad valorem, you're based on an estimated tax bill. Let's see. In the event of tax savings resulting from a tax appeal, third party professional cost to handle the appeal may be deducted from the savings, any pending tax appeal. So this is just basically if the tax bill comes lower and the seller feels like they paid too much. This discusses a little bit more about this. Buyer agrees to identify seller against any and all claims of the county and the city for unpaid ad valorem taxes for the year. Spells that out a little bit more. Closing date. So again, you had those options of right to extend closing date. Seller or buyer may unilaterally extend the closing date for 8 days. It's now 8, not 7. Upon giving notice to the other party. Either one, the seller cannot satisfy the title objections and needs more time. It can be satisfied through a payment of money, or to not prevent seller from conveying good and marketable title. Cannot satisfy title objections, excluding title objections that can be satisfied through paying title, or they can't do it whatsoever. It can be extended if the buyer's mortgage lender or the closing attorney is delayed and cannot fulfill their respective obligations by the date of closing.
Like,
Pro- Right, provided that the delay is not caused by the buyer dragging their feet or doesn't have the money. Yep. Buyer has not received required estimates or disclosures, TRID, the 3 days prior to. And buyers prohibited from closing under the federal regulations, so the party unilaterally assigns. Now, this is also where, yes, you get an automatic unilateral, but you also have to look at the situation and the healthy state of both parties. Are they willing to both be in agreement to extend? Then I would utilize the amendment to extend closing date for both parties are in agreement. Because again, think about it. Okay, this is the first extension. Got it. We just need a couple more days. We're going to both be in agreement. We're still happy-go-lucky. We're about to close. We're both going to sign off. And then another extension because life happens. And then another extension. You're getting somebody ticked off. And so long as the issue is still either the buyer, the seller, the buyer's lender, or the closing attorney, or the TRID situation, or it's the title objection. So long it's one of these 3 items, then you can use your unilateral card. Somebody's ticked off, fine. I just need a couple more days. It's going to happen this time, I swear. Utilize that unilateral. It's just, again, just a negotiation key. Keys and openers. So seller, it states in here, and I don't know why it doesn't happen. Seller shall provide buyers with all keys and openers and fobs and everything that they need to have access to the property and the community and amenities. In the event sellers required to return the items to the third party, seller shall provide buyer with instructions on how to contact them. Let's just say they're keeping the property for a little bit of time. The buyer still needs to have some way to access their property when they leave closing, and they can get the rest at the time of possession. Devices and fixtures. So again, it spells it out. Except as set forth above, if a system, device, or fixture conveyed with the property cannot be operated without a specific controller, then no later time than possession, they should provide the buyer with all controllers, which are required for the operation of the devices. Gas log system, air conditioners, ceiling fans, yeah, all sorts of stuff. Seller agrees to provide buyer with all the device credentials, including but not limited to the username and passwords for all devices, including access and guest codes. And seller may reset the devices to factory settings and provide them with information. I once had a client take over a property and we struggled hardcore getting connected to the Wi-Fi that was built in. So there was like extenders built into every floor. And Lordy knows we had horrific horrific cell signal out there. And then we couldn't get the Wi-Fi to work for days. And it was like pulling teeth with the seller to provide us, like to get into the system. Yep. Let me see. Closing attorney. Its buyer shall have the right to select the closing attorney to close this transaction. It says it right there. Buyer shall have the right to select. You see, oftentimes,
Still say preferred closing attorney.
yes. And you ask, what's the situation? Have they already pulled title? Sometimes they've done the legwork. It's an estate. They've done the legwork. You're like, okay. Or it's Harry. Like it was been under contract so much, et cetera, et cetera. I'm like, okay, they've done all the work. We can just plug and play and close. So just ask, what's the situation? Are you getting a kickback? So buyer shall have the right to select a closing attorney to close this transaction and hereby selects them. In any case where an individual closing attorney is named in this agreement, but they are employed by an owner, shareholder, member, or law firm shall be deemed, hold on, wait. Where an individual closing attorney is named. Okay, sometimes they like to say, I want to work with Big Bird. And it's literally like the closing attorney is written in on the contract as Big Bird. This is basically stating that we all understand it's going to be Sesame Street law firm. Like Big Bird works there. So that's just basically what that's saying. If buyer's mortgage lender refuses to allow that closing attorney to close this transaction, buyer shall select a different closing attorney acceptable to the mortgage lender. That's probably happened once in my entire career because they have big boy feelings and they get their big boy feelings hurt and they don't see eye to eye with another attorney. Again, that's only happened once. And I called them out on it. Closing attorney shall represent the mortgage lender in any transaction in which the buyer obtains mortgage financing. This is where I tell everyone, we are an attorney state. The attorney is closing on this loan. The lender orders the title gets ordered, it goes back to the attorney to read and review and dissect, basically. But at that table, they are neutral party to the seller and the buyer. They represent that lender. So don't go talking about that vehicle that you just closed, and bought the day before, or the fact that you just quit your job after the job verification phone call came through. Like, they represent the lender. In transactions where the buyer does not obtain mortgage financing, closing attorney shall represent the buyer in preparing the closing documents, attempting to clear title for the property, conducting the closing, dispersing funds, timely record deeds, et cetera, et cetera. So again, if the buyer's obtaining a cash deal, the attorney legally represents them at the closing table. Other than those services specifically listed above, nothing herein shall obligate the closing attorney to perform other legal services, including but not limited to certifying warranty and title for the buyer, except pursuant to an engagement agreement between them. Holder of earnest money. The earnest money will be paid to holder in the payment acceptable to the holder. So some attorneys may only allow wire. Most will accept check, ACH, and wire. They do not like, I've had one attorney accept cash, and that's challenging. I'm like, why did you accept it to begin with? That's a challenge, especially when it comes to financing. Do not allow your clients to submit cash as earnest money. There's no proof. And your lender needs that paper trail. And not every person knows that. I will tell you that now. Holder has the right to charge the buyer for any costs associated with receiving the earnest money, like wires, etc. The earnest money will be deposited into holder's account no later than 5 banking days after the binding date, or within 5 days after receiving it. If buyer writes a check or pays for an ACH for the earnest money and is deposited into the earnest money account, holder shall not return the earnest money until the check or the ACH has cleared the account on which the check was written or from where it was sent from. In the event, and another reason that y'all need to know this is so that you can point this out. So when you terminate, if you terminate and your client's like, well, when am I going to get my money back? That's the very first question. When am I going to get my money back? And you just sent it over to them. Today's Tuesday. You just sent it over to them Monday. If they've already gone through the process of depositing it, you have to let them know, hey, it's got to clear the bank before they can turn around the check. It's written in here because the next sentence it says, in the event an earnest money is dishonored by the bank upon which is drawn or earnest money is not timely paid, holder shall promptly give notice to the same to the buyer and the seller. Okay, that's something different. Let's go back to the termination. So yes, you have to let them know. It's typically 10 banking days or 10 business days in which they require before they'll cut a check, but just talk to the bank or talk to the attorney. Now this is saying that if for some reason it was dishonored, so basically it was no good, or it wasn't paid on time, but the date that in which you said it was going to be delivered, then you have to give notice to the opposite party. So there's a form and it literally just says notice. I had a client that wired the money on time, but it was after 12 noon on a Friday. That money wasn't going to get to the attorney until Monday. So I had to write a notice. I told the listing agent, first of all, and then I told the buyer, I'm like, hey, I have to disclose this. This is no problem. It's fine. It's fine. You have proof that you sent it. You're just not going to get it in time. And it's a notice, and you can check on the box, either buyer or sellers giving this notice, and what is the notice. And I just basically, spelled out exactly what happened, and you have to provide that. Buyer shall have 3 banking days from the date of receiving that notice to cure the default. And if they do not do so, then seller may terminate within 7 days of this agreement upon notice to buyer. If seller fails to terminate, then their ability to terminate is waived. So this is one of the very, very few ways that a seller can walk out of a deal, because it's really not written, and you'll discover that as we're reading further, it's really not written for a seller to walk away. However, so what just happened is that the buyer wrote a check and it either bounced or they didn't deliver it in timely. Notice was provided. They've got 3 days within that notice to get it fixed. If they don't have it fixed, then seller may within 7 days of that notice be able to terminate the deal. And so terminate the binding, they're no longer under contract. Do y'all have any questions about that? Something I definitely want to, so that was the holder of the earnest money, and we're about to go into earnest money next. I don't know if I don't think it goes into it. The rule about earnest money, it's like hot potato. You want to get it out of your hands as fast as humanly possible. You don't want to put it in your wallet. I won't put it in my purse. Nothing. I have like a certain spot in my center console that as I meet people and they hand me a check, it immediately goes in that top lid. I don't commingle it in any way, shape, or form, and I get it to the attorneys as fast as possible. Most of these attorneys have a Dropbox. They just need to know that you like, so you send them an email, hey, I dropped this off, because they don't come in and always check their Dropbox. Like Brett Jones, for instance, I now know has a Dropbox. But you just want to get it out of your hands as humanly possible, which is why I like wires. So when you go under contract, and because wiring money is so sensitive and potentially to be hacked, I try to get as soon as we go under contract and I'm sending out that notice to everyone, hey, we're under contract, I try to get the buyer and the attorneys to talking immediately. Hey, send the wire. I used to keep wire instructions. This is back before it was so hackable. I used to keep them filed in my system. So I'm like, oh, you're closing with Campbell and Brannon. Here's their wire instructions. I would just keep it. No. So, and sometimes it comes in an encrypted email or whichever. And I have often where the buyers are like, hey, I've got an email from such and such. I'm like, that's valid. And they'll send them the wire instructions, and across the board, I always tell them, print it out. When you get to your bank, call the attorney and say, here's what I have printed. Can you verify it? And then they give it to the bank, and they wire it just to reduce the chances of having them wire to Bora Bora. So again, get earnest money out of your hands as fast as possible if it's going to be a check, or have them wire it. I really don't like the USPS anymore. I don't like to have them put it in the mail. They can't seem to do it fast enough. If they do, if they have to, I have them take a picture of the check, send it to me, and I have them, what do you call it? Track it. I have them track it 100%.
And nowadays, it's like even just ask for like a signature upon arrival, just because it's so, they lose everything.
Right. Or if it goes to the office, like Keller Williams is holding on to it. If it arrives on a Saturday and Sunday, we're up creek. So it's, you have to really time it. You have to have that conversation. It's going to be a case by case basis. You're here, the holder has to have it on XYZ date. How can we do this fast? And again, something else to know, and this is good for obviously your wiring for closing funds at the time of closing. So this is good to have these conversations. Sometimes bank requires appointments. Sometimes banks require you to be physically in person. So people will literally jump on a plane and head here for closing, thinking they can wire from anywhere and their bank's not here. We've had that problem. Banks will only wire at certain times. They will stop wiring at a certain time. They could be open on a Saturday, but they don't wire on Saturdays. So it's like, you need to talk to your bank and find out the rules kind of thing if they want to wire.
He's like chicken.
But again, my person in New Jersey, it was after 12 noon and they didn't wire. So, okay. So this is talking a little bit more about that earnest money. And so we'll wrap up with earnest money and due diligence. We'll go a hair over, but these are two really, really big important items. So earnest money, entitlement to earnest money, subject to the paragraph below, due diligence, buyers shall be entitled to the earnest money upon failure of the parties to enter into a binding agreement. So like that section A, where we're already holding on to their earnest money. So they shall be entitled if they fail to go into a binding agreement. Failure of any unexpired contingencies or conditions in which this agreement is subject to, such as due diligence, appraisal, financing, etc. Termination of this agreement due to default of the seller. Title, can't produce a good title, or termination of this agreement in accordance with a specific right to terminate set forth in this agreement. Sale contingency, or a stipulation written in there somewhere. Otherwise, the earnest money shall be applied towards the purchase price of the property at closing, or if other funds are being used to pay the purchase price, then it shall be returned to buyer. All right. Any questions there? Disbursement of earnest money holder. So again, closing attorney most often, or an agency, shall disperse the earnest money upon closing of the property, a subsequent written agreement of buyer and seller, an order of a court or arbitrator having jurisdiction over any dispute involving the earnest money, or the failure of the parties to enter into a binding agreement when there's no dispute. In addition, holder may disperse the earnest money upon a reasonable interpretation of this agreement, provided that holder first gives all parties at least 10 days notice stating to whom and why the disbursement will be made. So termination happens and it says Big Bird should receive the money. And Cookie Monster's like, no, I don't agree with that. I'm not signing off on that. I should receive the money. So what happens? It's got to go to the holder. And the holder reviews everything, reviews the contracts. Sometimes emails have to be provided. Other information has to be provided. That holder has to play neutral party. So anyone that agrees, like attorneys, when they agree to be the holder, they agree to kind of be that neutral party. And they review, well, why are you terminating? Under what condition, failure of this or this or this. And they'll review deadlines and they'll review timestamps, which is why it's important if you're terminating that you're sending it to the email address that's on the contract. Not their like AOL account or something. Oh, because this one's not working, send it to my AOL. Send it to both. So anyway, so all of those details are going to be reviewed. Okay, so back to, and then that's when the holder, again, gives everyone 10 days notice as to whom and why. No interpretation shall be made by holder dividing the earnest money between buyer and seller. It's all or nothing. Any party, real estate licensee, or any other person having knowledge or of interest in the disbursement of the earnest money may object to or provide information regarding the proposed disbursement by giving written notice of the same to the holder within the above referenced notice period. So within those 10 days, objections not timely made in writing shall be deemed waived. So they're giving notice, you have 10 days to object. If holder receives an objection or other information, again, supporting documents, and after considering it, decides to disperse the money as originally proposed, holder may do so and send notice to everybody. If holder decides to modify based on that information, they shall send a new 10-day notice to the parties stating the rationale for the modification and to whom the disbursement will be now made. So again, if they change their mind, have to send another 10-day notice, letting them know why they changed their mind and to whom it's to be changed to. Holder may disperse the earnest money to the seller by check in the event the holder makes a reasonable interpretation. Sends a 10-day notice of a proposed disbursement to buyer and seller. The above referenced check shall constitute liquidated damages in full, settlement of all claims of seller against buyer and the brokers in this transaction. Holder may require seller to sign a W-9 before issuing a check to seller if it's more than $600. Such liquidated damages are a reasonable pre-estimate of seller's actual damages, which damages of the parties agree are difficult to ascertain and are not a penalty. Basically, once we agree to this, it's done. It's in full. It constitutes all liquidated damages. It's trying to prevent you from going and suing. Any questions on that? It is not fun. It is not a fun process. It happens. You really just try to avoided at all possible costs. That's another reason why you CYA and you document. And it's just not a quick process. That's what you're telling your clients. If an earnest money dispute cannot be resolved after a reasonable time, holder may interplead the earnest money into a court, basically taking it up a new level. Holder shall be reimbursed for and may deduct costs, expenses, and attorney fees from any funds interpleaded. So basically the attorney may come back and shall be reimbursed and may deduct the cost of their efforts. The prevailing defendant in the interpleader lawsuit shall be entitled to collect its attorney fees and court costs as well. All buyers hereby covenant and agree and indemnify and hold the holder harmless from and against all claims, injuries, suits. Attorneys drafted this one and the attorneys are covering their butt, basically. They agree not to sue holder for any decision making, etc. So that's just a CYA. I can't blame them. So buyer's right to inspect the property and the due diligence portion gets a little long, but I promise we'll wrap up there. Unless otherwise stated herein, we all agree that property is being sold in a as-is condition with any and all faults. Therefore, the buyer and the buyer's representatives, i.e. inspectors, have the right to carefully inspect the property to make sure it meets the needs of the buyers. Also, if they're concerned if it was ever a meth lab or a dump site, they can go to this website. Buyer's right to inspect the neighborhood. In every neighborhood, there's conditions which can affect buyer. They may find objectionable. It's the buyer's sole responsibility to become familiar with the area, to areas of concern such as landfills, quarries, power lines, airports, cemeteries, prisons, stadiums, odor and noise, crime and school, land use, government, tax maps, etc. Also check the sex offender list as well, so that you know where sex offenders are in your neighborhood. They actually have the right to inspect all the way through closing. Upon prior notice to seller, buyer and their inspector shall have the right to inspect closing to enter the property at buyer's expense, reasonable times, and without limitation to conduct inspections, examinations, evaluations, appraisals, surveys, and tests, meet with contractors and vendors, measure for renovations, determine the condition of the property, and confirm that any and all agreed upon repairs have been made. Seller shall cause that this is huge. Seller shall cause all utilities, systems, and equipments to be on all parts of the house to be accessible, including basements, attics, and crawl spaces, so that buyer may complete all inspections. It's great to know though ahead of time, hey, I noticed the water was off. Hey, I noticed the electricity was off. If it's a foreclosure, if it's a short sale or something crazy like that, it does say in black and white that it's the seller's responsibility. Some foreclosure companies will say, I do not care. We're letting you know ahead of time. We will not turn on the utilities. Most utility companies will turn it on for like a period of like 2 days or something at a cost to the buyer. It also does say reasonable times. Upon prior notice to seller, reasonable times, you can come in and inspect. And it's also called being a good human and knowing that they work from home. Hey, knowing that I have the house for 3 hours on an inspection day, let's see if we can get as many contractors in there as possible. Or, hey, I'm going to do a complete remodel gut job or whatever. I'm going to pick a day and I'm going to try to get as many vendors in there as possible. You're not going in 5 to 8 times between the binding and closing in a like 3 or 4 week period. Yes, I understand that happens and you're trying to, give them as much notice, but I can tell you it's a lot easier to, what's the Southern saying? Can attract bees more with like sugar than vinegar.
Yeah, but it's just like
Yes,
sugar than shit.
there you go.
No, that's not right.
It's just,
I need them something. I don't
I-
know what it is.
I get my phrases messed up all the time. I'm only partial Southern. Born in Georgia, but Yankee parents. let me see. Oh, something else. Buyer's inspection indemnification obligation. Buyer agrees to hold seller and all brokers harmless from all claims, injuries, or damages related to the exercise of the above inspection rights by buyer and their representatives, inspectors. And buyer shall promptly pay the seller the actual cost to restore any portion of the property damaged or disturbed from testing or other evaluations. Notwithstanding, this shall not apply to damage resulting from defects of the property uncovered during the inspection. If your inspector falls through the ceiling from the attic, you're paying for it. The buyer's paying for it. It's in bold, like letting them know hey, I don't want to use your professional inspector. I know that you've had a lot of great great experience with them, et cetera, et cetera. Can I get Jim Bob to come in and do the inspection? And you're just like, one, you don't have to be licensed in the state of Georgia. Scary. And are they going to write an inspection report? And do they have any sort of insurance coverage? And do you feel comfortable and confident that they're not going to damage any part of the property? Because you're going to be liable. It's in bold on the contract. And they're like, oh, okay, maybe I shouldn't.
How does that work with like lead paint, like lead-based paint testing, because they have to take a chip of?
That's the next section. Any portion of the property built prior to 1978, lead-based paint is hereby attached. Buyer shall have the right to conduct a lead hazard evaluation within 10 days from binding. If buyer gives the right to terminate this agreement if lead-based paint was found in such notice of termination, it shall be waived. It doesn't really say. It does. Same thing with and the seller has to agree with that, and they have to try to do as limited damage as possible. Stucco, which is very common down in Metro Atlanta. Hate stucco. You have to kind of damage the siding to be able to. So it's one of those like
They kind of know that's gonna be coming.
right.
Kind of excluded in that part of the.
Any determination or conditions evaluated to equal or better than the condition it was prior to such testing and evaluations. That's really where you get a company in there that is going to do the least amount of damage as possible.
Yeah.
To inspect. But like in septic tanks, I hate disturbing the earth, especially if it's like one of those pristine lawns. I like the seller to have the septic tank cleaned out. Because what if it doesn't work out? Now we've just, as a buyer, given this seller a clean septic tank. But it's also, we had to disturb the earth, and you might not like it. Yes. If the property is being sold subject to a due diligence period, then A, this agreement shall be an option contract during which time buyer shall have the option for any reason or for no reason. This is where I say if the wind blows in the wrong direction, to terminate this agreement upon notice to the seller given prior to the expiration of the due diligence, in which case buyer shall be entitled to a return of the buyer's earnest money without penalty. So again, this is B8. Is it 8? Yep. B8F. It does not get more clear than that. This is how, this is your get out of jail free card. And hey, you just spent a couple $100 on an inspection. Why don't we do the right thing and at least ask the seller? Well, you might surprise yourself. Like the seller might consider it and might be in agreement with all the repairs that need to be made. So let's at least ask and utilize the inspection report that you just paid for versus just abruptly terminating. Buyer may, during the due diligence period, seek to amend this agreement to address any buyer concerns buyer has with the property for this agreement. And if buyer has not terminated this agreement, buyer shall accept the property in the as-is conditions subject to any amendment that this agreement to address concerns agreed to by all parties. So what it doesn't say in there is that you really need to get an agreement. All parties signed off on it prior to 11/59, the day of the due diligence expiration. Not a present it. Again, all parties come to an agreement, or you need to send a termination prior to 11/59 that night. just good standard habit and practice is you want to at least give the seller a good 24 hours. They might be quick decision makers and they might not, or the seller might have to physically get over there and get them to sign. You want to, again, be good human and try to give them time to be able to, and that's less stress for everybody. You don't want to wait till the 11th hour before you're getting all this done. So what's the word? Okay, if I can't say it, then I can't use it. I adamantly, I adamantly push to have them do the inspection as far, in the beginning as possible so we can get the inspection report, because that's when they say you need to get a licensed professional in roofing, HVAC, something. And that gives us time to get that second opinion in there. Or the mold test results back, the radon test results back, et cetera, and be able to compile the inspection report, the amendment, and present it. Seller's duty to disclose, seller shall disclose to buyer any and all known latent or hidden defects in the property that could not be discovered upon them doing a careful inspection of the property, such as, like the inspector is not going to come into this room and tear down the paneling to see if there is a crack in the foundation. So if the seller happened to have this room finished out themselves and they know there's a 2-inch gap crack here, they're supposed to, again, disclose that. Supposed to. Warranties transfer, seller agrees to transfer to buyer at closing subject to buyer's acceptance, seller's interest in any existing manufacturer warranties, service contracts, termite treatment, repair guarantee, et cetera, to be transferred to buyer. Roof, termite, like they mentioned, generator. All guarantee upon repairs and replacements shall be performed in a good and workmanlike manner prior to closing unless otherwise agreed to in writing by buyer or seller. I write that in the amendment. I write that I have a specific stipulation and it talks about the type of contractors and the receipts within certain amount of days and such. So
Do you prefer to have your buyers pick the contractors and stuff? Because then they know, like,
if they know them, again, I have a lot of clients that they don't know, Steve from Adam down here. So they often rely on us.
Yeah.
Oftentimes too, they can see the quality of the house and they're just like, yeah, I don't want anybody that the seller is going to select. That's why I want money so we can do it ourselves. Or Chris, who have you used in the past that, we can talk with? And you try to give them at least 2 to 3 names.
Would you have it re-inspected after the fact?
Up to the buyer. You offer that, sometimes they'll, re-inspect for a nominal fee.
What's up, everybody?
Yep.